because of the consequences, again, this goes back to the just cause insertion in the early 90s, because marking someone as losing their job for misconduct guarantees, there's an IDI. Anytime there's an M, it forces a phone call, HR, and the EI investigator must actually do an investigation to substantiate that. And because of the consequences of it, it's actually a criminal code offense. So if I do,
I just want to clarify what you're talking about when you say that the just cause was added in the 90s. That's the Unemployment Act. Is that what it's called, the Unemployment Act?
correct, yes.
Yeah. I just want to make sure people understand where it's coming from.
So here's section 398.
And also, Matthew, who is the person who implemented the Unemployment Act? Where did it come from? Who was the prime minister at the time?
Depends on which iteration, but most of the issues have happened under someone with the name Trudeau. Take your pick. They both have done the damage.
Yeah, yeah.
So as you can see, section 398 of the Criminal Code, everyone who with intent to deceive, that's important because there has to be intent. If anyone falsifies an employment record by any means, they are guilty of a summary conviction offense. And if I pull up an example of a record of employment, you can see down in the bottom corner here, box 22, I am aware that it is a criminal offense to knowingly make false entries and hereby certify that all statements on this form are true. So every time you submit a record of employment, you are swearing an affidavit under penalty of criminal code, section 398, that there is nothing dishonest, particularly the reason code.
Yeah.
And there's lots of warnings. So I have here the official record of employment guide. This is maintained by Service Canada. So if I go down to block 16, which is the reason code, right here, it is a serious offense, criminal offense, to misrepresent the reason for issuing an ROE. If you knowingly make a false or misleading submission, you can be subject to fines and prosecution. And it says knowingly, you must be fully aware with full knowledge of the facts. That's important. Go down to block 22. And you can see under certification, it also says certification. There was a lot of confusion during the pandemic. So they actually issued a special document specifically called Preparing Records of Employment during COVID-19. So this version I have here was the one that was active at the time our record of employment was prepared, December 2021, which was when most people in that block. COVID-19 vaccination. When employees do not report to work because they refuse to comply with a mandatory vaccination policy, either mark them as having quit or leave of absence. Code M is only used if you suspend or terminate an employee. So if you refuse to report to work because the policy says you're on leave of absence, code N. They made it clear. And it's a criminal offense when you falsify and say someone has been dismissed when they're on leave and they're still in an employment relationship. That's a problem. And there's knock-on effects too. Because if I go down factum 246, here are relevant sections from the EI Act. Any workers on approved leave will be compensated at any time are deemed employed under the statute. This means that EI premiums are owed for the entire leave period. So EI regulation section 14.6, anyone who has an 11.3 type of leave is not considered to have an interruption in earnings, regardless of when or how they're paid. So if you're on leave for one of these reasons, which is a leave under agreement with the employer, you continue to be employed and you receive some pay at some point, regardless of how, regardless of when, you are employed. And then finally, AI regulation. If the remuneration is paid in respect of a leave, it shall be allocated to that period, that time of leave, at the rate at which it was compensated. So you have to be paid for what your rate of pay was at that time.
Mm-hmm.
So if people are on leave of absence, and that happens to be a year or two, 2% of every dollar they're supposed to be earning is supposed to be going to EI. If you mark them as being terminated with an M, guess what? There's no employment relationship.
Mm-hmm.
So I'm not going to speak to Purelator, but in general, people who got an M who are on leave of absence are in a situation where their employer is supposed to be paying premiums for that entire period of leave. So based on the number of employees, that could be millions of dollars. So this is not just a criminal falsification times hundreds of records. We're also talking millions of dollars
Mm-hmm.
in premiums.
Mm-hmm. Mm-hmm. Matthew, as this continues and evolves, this conversation tonight, will you be talking about jurisdiction with regards to
Yep.
okay, because I don't think you and I have talked about this, but the jurisdiction with the Consent Act and the Medical Professions Act and all these different regulations and acts that exist. So, okay, great. I'll let you keep. I just wanted to ask if that's something that's on the table for the evening.
Yep. It may not. Well, I'll let you ask questions at that point because I'm sure you're going to ask things that are expanded outside of our case.
Mm-hmm.
Uh, I do want to quickly address changing facts. Um, Facts are supposed to be settled, right? Findings of fact are not supposed to be disturbed without good cause.
It's not a living, breathing thing. Facts are facts.
Exactly. So to change a fact is actually you can be disbarred if you're caught misrepresenting or changing facts. Uh, I want to just quickly touch on the fact that the EI Commission was changing facts. Um, I can't pull up the official documentation because it has SIN numbers, but many people will find themselves in this sort of situation. The entire time that we were going through the EI process with the Commission, we were marked as leave of absence without just cause. And obviously, to determine that someone is on a leave of absence without just cause, you actually have to do a just cause analysis, which they did not do. And again, this applies to the vast majority of us. When we finally applied to have our case heard at the tribunal, we received a filing from the EI Commission saying they made a clerical error and they changed the status of our case from leave of absence to suspended due to misconduct. To hear the actual paragraphs, the attention of the tribunal is drawn to the fact that a clerical error was made in the notice sent to the claimant. It said that he was on a leave of absence, whereas it should have stated he was suspended due to misconduct. This is the first time that suspended is used anywhere in the record. It was not used by anyone at Purelator. And you have arbitrarily the tribunal or the EI Commission deciding that, well, if you're on a leave and you caused your leave, that's equivalent to a
Mm-hmm.
suspension. So we're just going to call it a clerical error. And they actually cited case law, which is ridiculous, that said this: an error which does not cause prejudice is not fatal to the decision.
But it does cause prejudice.
It's switching between whether or not you're
Yeah.
approved or not. But it shows you what we're dealing with, and it
Mm-hmm.
needs to be called out as such, right?
Mm-hmm. Mm-hmm.
To say that a suspension is equivalent to a leave of absence is I mean, it should be a crime. These are documents being put before a court.
Mm-hmm.
Um, and I think people should check if they are someone they know had this issue. Look and see if their tribunal representations from the commission have similar wording, because it is interesting that as long as we were dealing with them, and the vast majority of claims never get appealed to the tribunal, they could say whatever they wanted. But the moment their decision was to be subjected to an internal or external independent review, now they're finding clerical errors, and the clerical errors are just changing the entire point of
Mm-hmm.
the
Mm-hmm.
exercise.
Mhm. And who's like, where is this clerical error originating from? It's the tribunal saying, oops, we made a mistake. Like, what is
No, it's the EI Commission,
the EI Commission? And
yeah, which
how
is all
would they,
part of
but how
Service
would,
Canada.
and how would they, like, they're claiming that, like, when it was entered in the system, it was entered incorrectly, or like, at what point in the process do they identify a clerical error? Is it,
They didn't identify it until it was subjected to review from the tribunal. Which,
so
if you
at
really
the
boil it
tribunal
down,
stage is what you're
yeah,
saying, right?
yeah, and
Okay.
what they're saying is the record is a clerical error because what they're doing is amending their prior
Yep.
findings and their prior decisions,
Understand.
saying,
Yep.
the official documentation we sent you had a typo, and that typo is just a
Oopsies.
typo,
Yeah.
and it just so
Oopsies.
happens that it's 180-degree
Mm-hmm.
flip.
Mm-hmm. Mm-hmm.
We need to call this out for what it is. You're changing facts
Yep.
when it's convenient, and lawyers would be sanctioned by the bar if they were to change facts halfway through a series of filings.
Mm-hmm.